I heard the vehicle before I saw it. The low, deliberate growl of a heavy engine pulling up across the road, gravel settling, then silence. I was still at the kitchen counter with my first cup of coffee when the knock came. Not a polite knock. The kind that carries authority behind it. The kind that means the person on the other side has already decided how this morning ends. I set the mug down and went to the door. Corporal Reed stood on my porch in full RCMP uniform, a sealed envelope pressed against his chest, and a look on his face that told me this was not the kind of morning he had asked for. Through the gap in the cedar trees along the road, I could see my son-in-law sitting behind the wheel of his Lexus with his window rolled down and his phone raised. He was recording, and he was grinning the particular grin of a man who believes he has already won. "Hurry up, Dad," he called across the road, his voice moving easily through the cold October air. "We've got a demolition crew on standby, and they don't work for free." I did not raise my voice. I did not shut the door. I took the order of possession from the corporal, read the first paragraph with great care, and asked him one single question. One. And the color drained from his face so completely I thought he might need to sit down on my porch steps. "My name is Fletcher Oak. I'm 67 years old. I spent 35 years as a structural engineer with BC Hydro, the kind of work where a miscalculation doesn't just cost money, it costs lives. I retired 8 years ago to a 4-acre waterfront property on Vancouver Island, tucked above a rocky bluff overlooking the Strait of Georgia. I built the house myself over 4 years of weekends. 6 rooms, a wraparound porch hand-planed from Douglas fir, and a view that still stops me cold on mornings when I forget to brace for it. My wife chose the site. We drove every logging road on this island for 2 summers before she stood on that particular piece of ground, looked out at the water, and said that was the one. She planted a kitchen garden along the south wall the first spring. It has come back every year since she passed, even in the seasons when I forget to tend it. She died of ovarian cancer 6 years ago. I have not been the same since, and I have made peace with the fact that I never will be. Welcome to Chosen Vengeance. I'm glad you found your way here. Before I go any further, some details in this account have been shaped for storytelling purposes, and any resemblance to specific real individuals or events is coincidental. What matters is the truth underneath it. I have one daughter. Her name is Serena. She's 40 years old and works as a mortgage broker in Victoria. She knows property law the way most people know their own phone number, backwards and without thinking. She is sharp and polished and very good at reading people. I paid for her university. I covered the down payment on her first condo. When her marriage was struggling 3 years ago, I drove 4 hours each way to sit with her at a kitchen table and listen for as long as she needed. Her husband, my son-in-law, runs a real estate development company out of Victoria. He is 44, well-dressed, and speaks with the easy confidence of a man who has never seriously doubted his own intelligence. He has completed 2 mid-rise projects in Langford and a townhouse development in Saanich. By most visible measures, he is successful. He is also the reason I am telling you this story. What happened between us didn't begin with cruelty. It began, as these things often do, with tears. 5 months before Corporal Reed appeared on my porch, my son-in-law showed up at my door on a Thursday evening in late May. Serena was with him. I knew from the way she walked up the path, shoulders forward, eyes fixed on the ground, that something was wrong. I brought them inside, put the kettle on, and sat across the kitchen table from them without saying much. My son-in-law did most of the talking. He explained that a municipal council in Langford had launched a zoning appeal against his largest current project, a mixed-use development he had been building toward for 2 years. The appeal had frozen his building permits. That had triggered a clause in his construction financing agreement with the bank. The bank now required him to show additional collateral to maintain the credit line. Without it, the project would collapse. Years of work. Everything he had built. Gone. He looked tired. I'll give him that much. He looked genuinely tired. Then Serena reached across the table and took my hands. Her fingers were cold. She looked at me the way she used to when she was very small and something had frightened her. And she said the words she knew would reach past every rational thought I still had. "Dad," she said quietly, "Mum always made you promise you'd look after me." I have never been able to hear those words without feeling the weight of that hospital room. The thin light, the sound of the machines, my wife's hand in mine, and what she asked me to swear before she slept. Serena has always known that. She pressed on it deliberately like a thumb finding a bruise. She told me they weren't asking for money. What they needed, my son-in-law explained, was to temporarily list my property as part of a joint ownership structure, a recommendation from their accountant. It would show the bank solid asset backing. He was quick to point out that it also made sense for my own estate planning. Adding his company to the title in a limited capacity would reduce probate fees when I eventually passed. Standard practice, he said. Families did it all the time across the province. I tensed. I told him I wasn't comfortable putting this land into any corporate arrangement. I had built this place. It was my foundation. He pulled back immediately, both hands up, voice patient and measured. He said I was misreading the situation entirely. It wasn't a transfer of ownership, just a technical administrative adjustment. My name would remain on title. Nothing about my life would change. He would handle all the paperwork and bring a notary in the morning. Everything would be done in an hour. Serena kept her hands over mine and cried quietly while he talked. I looked at my daughter and I said yes. A BC notary arrived the following morning with a thick folder of documents and the careful, impersonal efficiency that should have made me far more suspicious than it did. In British Columbia, notaries handle property transfers routinely, licensed professionals, regulated and credentialed. This one had all the right paperwork displayed on the folder he set on my dining table. My son-in-law stood behind him throughout, guiding me through each page with a steady, reassuring voice. The opening sections described exactly what he had outlined the night before. A joint interest arrangement, estate planning language, probate cost reduction. It all matched. I read those early pages carefully, and it made sense. I should have read every single page. I didn't. By the middle of the stack, my eyes were heavy with the weight of the night before, and my mind was half occupied with my wife's voice. I signed wherever the tabs directed me. What I did not see, buried with surgical precision in the middle of that pile, was a completed Form A transfer of land. Under the BC Land Title Act, a signed and notarized Form A transfers full registered ownership from one party to another. I had not adjusted a joint interest. I had not amended an estate plan. I had surrendered the entire property, 4 waterfront acres on Vancouver Island, to a numbered company my son-in-law had created and controlled. I gave them everything I owned and called it a favor. 3 months passed quietly. I watered the garden. I had my morning coffee on the porch and watched the fog come in off the water. Serena called twice a week. My son-in-law was cheerful. The crisis, as far as I could see, had resolved itself. Then one afternoon in late August, a man I had never seen drove through my gate in a white pickup with a magnetized company logo on the door. He carried a surveying tripod and a digital level and began setting up near my western boundary fence. I crossed the yard and asked what had brought him there. He checked his tablet and told me, with the careful neutrality of someone sensing they had stepped into something complicated, that he was conducting a geotechnical and topographic survey on behalf of a Victoria-based development company. The survey had been ordered to support a permit application for a luxury waterfront condominium development. He read me the civic address. It was mine. I asked for the development company's name. He read it from the file. It was my son-in-law's company. I thanked the surveyor, asked him to carry on with his work, and walked back inside. I sat at the kitchen table for a long time without moving. Then I picked up the phone and called Serena. She answered on the 3rd ring. The background told me everything before she said a word. I could hear an upscale restaurant, the low murmur of other conversations, the clink of glasses, the kind of ambient quiet that costs money. She was not managing a financial crisis. She was somewhere celebrating something. I kept my voice level and asked her about the surveyor. She sighed. She used the tone she had been developing over the past year for speaking to me. Patient, slightly elevated. The tone people use with someone whose grip on reality they've decided to manage. She said it was just a routine assessment tied to the estate paperwork. She said I shouldn't worry about it. She said I should go back to my porch. I said a routine estate assessment doesn't include a permit application for a condominium development, Serena. There was a brief pause, the kind where someone is deciding whether to maintain the performance. Then she said she really did have to go, that she loved me, and the call ended. I am an engineer. I spent 35 years assessing structural risk on hydroelectric infrastructure. When a reading is anomalous, you do not dismiss it because you want the structure to be sound. You follow the data. I sat down at my computer and logged onto the BC Land Title and Survey Authority. For a $10 search fee, any person in British Columbia can pull the registered title on any property in the province. I typed my civic address, I waited, and then I read what came back. My name was no longer on the title. A numbered company, BC 0884331 Limited, was the registered owner. The transfer date was the morning after the notary had sat at my dining table. I printed the results. I set them next to my coffee mug. I sat with them for a long while. Then I drove to Victoria. I did not call ahead. I parked on Blanchard and walked to the office of a commercial litigation lawyer I'd been referred to years ago by a senior colleague at Hydro, a man known in legal circles for what opposing counsel once described as the most thorough and unrelenting approach they had ever faced. His name was Quentin Sorel. He worked out of the 9th floor of an older building near the Empress, surrounded by binders and a harbor view he clearly never looked at. He was compact, precise, and listened without interrupting. I told him everything. I showed him the title search. He asked me several very specific questions, then excused himself for 20 minutes. When he came back, he set a fresh printout on the desk between us. The fraudulent Form A had been filed with the Land Title Office the same afternoon the notary left my house. The transfer had cleared without complication because every field was correctly completed and the notary's stamp was legitimate. What was not legitimate was what I had believed I was signing. Quentin had also pulled the corporate registry records for BC 0884331 Limited. My son-in-law had incorporated that company 3 weeks before the Thursday evening when he and Serena appeared at my door in apparent crisis. 3 weeks before the supposed emergency. This had never been desperation. It had been planning. Quentin went further. Within 24 hours, through a title insurer's investigator he worked with regularly, he had confirmed the rest of it. My son-in-law had taken the fraudulent Form A to a major chartered bank and used the 4-acre waterfront property as primary collateral to secure a construction loan of $1.9 million. The funds had already been disbursed. A pre-sale agreement with a Vancouver developer had been signed 6 weeks earlier, before the surveyor arrived, before the permit application, before any of it. The development plan called for the demolition of my house and the construction of a 12-unit luxury condominium building on the site. The oak tree my wife had planted our first spring was scheduled to be cleared in 41 days. I sat with that. I let it settle completely. Not just the theft, the choreography of it, the tears at my kitchen table, the invocation of my wife's name as a crowbar. They had built this trap over months, engineering every emotional pressure point with the precision of people who had studied exactly what would reach me. Then I told Quentin to search further back in the title history, before any of this. Go back to 2018. He typed, he scrolled, and he went very still. In 2018, 18 months after my wife's diagnosis, I had sat down with an estate lawyer in Victoria and made a decision that my wife had quietly asked me to consider. She knew Serena. She loved her completely and without qualification, and she also knew her daughter's long-standing comfort with expensive things and her husband's appetite for risk. My wife had been afraid that after she was gone, the land we had built our life on might eventually be maneuvered away. We had established an alter ego trust under the Income Tax Act of Canada, a vehicle specifically available to Canadians aged 65 and older, in which the grantor transfers assets to a trust and remains the sole lifetime beneficiary. The trust held registered title to the property. An independent trust company in Victoria served as trustee. I retained the right to live on that land until I drew my last breath, but no subsequent signature I placed on any document had legal authority to transfer, encumber, or dispose of the asset held within it. The Form A my son-in-law had filed was not voidable. It was void. It had no legal effect from the moment it was stamped. Quentin leaned back slowly in his chair. He was quiet for a long moment. He walked into a federally regulated Canadian bank, he said at last, his voice dropping to something careful and precise, and used a document that never existed in law to borrow $1.9 million against an asset he never owned. Yes, I said. That is not a civil matter. No, I said, it isn't. Under the Criminal Code of Canada, fraud over $5,000 under Section 380, uttering forged documents under Section 368, fraud against a federally regulated financial institution, RCMP commercial crime section territory. The moment we filed, his assets would freeze. I asked Quentin to wait. I told him I wanted them to execute the eviction first. I wanted my son-in-law to walk a fraudulent order of possession directly in front of a uniformed officer. I wanted their intent fully on the record, in daylight, with a witness in uniform standing between them and me. He studied me for a moment, then he nodded. I drove home and began the careful work of becoming the man they already believed I was. Over the weeks that followed, I played the role with deliberate, unhurried precision. I left my reading glasses in the refrigerator and let my son-in-law find them when he reached in for a beer. I called Serena by her mother's name twice during phone calls, once casually enough to pass as a slip, once with enough bewilderment to watch her posture ease with satisfaction. I let my voice get thinner and more uncertain. I mentioned tightness in my chest. I let sentences trail off mid-thought. They believed every bit of it. I could hear it in the shift of Serena's voice, that particular brand of patient condescension that only surfaces when someone has decided they are dealing with a problem that is quietly resolving itself on its own. I invited her for tea on an afternoon in late September. She came, sat at my kitchen counter, and spent the better part of an hour managing me with the bright, hollow warmth of someone performing kindness for a private audience. On the kitchen windowsill, plugged into the wall like an ordinary phone charger, was a small voice-activated digital recorder. She never looked at it. When she excused herself to take a call in the hallway, I sat completely still and listened. "It's fine," she said, her voice dropping the performance the moment she believed she was out of earshot. "He's getting worse every week. We don't need to worry about him contesting anything. He can barely hold a conversation together." A pause. "Once the order goes through, we get him placed in care and let the prescriptions lapse. Without the blood thinners, his follow-up is on the mainland. He won't get there in time." I sat at my kitchen table and listened to my daughter schedule my death with the matter-of-fact efficiency of someone canceling a subscription. When she came back into the kitchen, I smiled at her and said the lavender along the south wall was looking well this year. She agreed, collected her coat from the hook near the door, kissed my cheek with complete manufactured warmth, and left. The recorder had captured everything. That evening, it also captured a conversation I listened to remotely. Audio transmitted to my phone while the device sat on the windowsill of my kitchen. During a subsequent visit, when I had excused myself to the living room and she had assumed I was asleep in my chair, my son-in-law had come to collect her. Their voices carried clearly. His easy, triumphant, 1.9 in the account. By the time anyone surfaces the trust issue, we're 3 jurisdictions clear. Hers, what about Dad? He's got maybe winter without his meds. The timing takes care of itself. I called Quentin the following morning. He played the audio twice in his office without speaking. Then he made a phone call of his own. The RCMP commercial crime section moves with a particular kind of patience. They do not move until the case is airtight, but when it is airtight, they are absolute. The morning Corporal Reed knocked on my door, I already knew what the order of possession was. Not a legitimate court instrument, but a filing my son-in-law had obtained through a BC Supreme Court application built entirely on a fraudulent land transfer. I knew what was coming after, because Quentin had spent the previous 2 weeks making sure what came after would be inescapable. I stood on my porch in the October cold and read the document. Across the road, my son-in-law sat with his window down and his phone raised. Beside the Lexus, my daughter stood with her arms crossed, her gaze fixed on the middle distance, not quite willing to look at me directly. Corporal Reed was clearly a decent man. He looked uncomfortable in a way that told me he had expected a routine possession matter and was already registering that something about this particular morning was wrong. I looked up from the order. "Corporal," I said, keeping my voice entirely steady, "before you proceed any further, before you make what I want to assure you would be the most consequential professional mistake of your career, I want to ask you one question. Are you aware that the property named in this order has been held inside an alter ego trust since 2018, and that any form of transfer of land signed by me personally carries no legal authority over assets held within that trust?" Because what I need you to explain to me is what forged document my son-in-law used to satisfy a BC Supreme Court judge that a valid transfer had occurred. Corporal Reed looked down at the order in his hands. He looked back up at me. He swallowed. His hand drifted from his duty belt. "Sir," he said carefully, "the paperwork came through the land title office with a registered transfer on file." "A transfer that is void in law," I said. "That document you're holding is the physical instrument of a federal fraud. The bank that issued the construction loan against this property is a federally regulated Schedule I institution. Your order is built on a ghost." He started to respond, stopped, started again. "What would you like me to do, Mr. Oak?" "Stand here with me for one moment," I said. "Don't approach the vehicle across the road. Let them believe they've already won." He stayed. Between two clay pots my wife had brought back from a market in Duncan, sitting on the porch railing where I had placed it before sunrise, was a Bluetooth speaker. I took out my phone, paired it, and turned the volume to its ceiling. I pressed play. My daughter's voice came out of that speaker and moved across the quiet October street, like something that couldn't be stopped. "Without the blood thinners, his follow-up is on the mainland. He won't get there in time." Then my son-in-law's voice, 1.9 in the account. The timing takes care of itself. Front doors opened. A neighbor appeared on her steps. Another came to stand at his gate with his coffee still in his hand. Corporal Reed had gone completely still. His hand found his radio. Across the road, my son-in-law had lowered his phone. The grin was gone. In its place was something I recognized from years of engineering review panels, the expression of a man who has just understood that a structure he trusted with his life is in catastrophic free fall. My daughter had both hands over her mouth. I let the recording run. I let the whole street hear the voices of two people who had calculated my death over a kitchen table, celebrating a theft built on paper that had never held legal weight for a single day. The RCMP unmarked vehicles came around both ends of the block before the corporal had finished transmitting his call. Plainclothes officers, commercial crime section, already briefed, already in position. Quentin Sorrell stepped from the rear vehicle at the far end of the road, smoothed his collar, and gave me one quiet nod. My son-in-law threw the Lexus into reverse. One of the unmarked units was already across the end of the driveway before his rear wheels had fully turned. He sat behind the glass, hands rigid on the wheel, understanding arriving in full. I watched the officers move. I watched the handcuffs appear. My daughter's knees gave way at the sound of them. She looked up at me from the road, the same look she had given me across every kitchen table I had ever sat at with her, searching for the soft place she had always found, the father who would absorb whatever she asked of him, who would stand between her and the consequence of whatever she had chosen to do. I looked at her from my porch. I thought about the hospital room, the thin light, my wife's hand in mine, and the promise she asked me to keep. I thought about a Thursday evening in May, and cold fingers wrapped around my hands, and my daughter's voice saying the words she knew would reach me. And then I thought about a kitchen windowsill in September, and a voice dropping all pretense, calm and unhurried, telling someone that the timing would take care of itself. "I kept every promise I ever made to your mother," I said, my voice carrying clearly across the space between us. "You used those promises to rob me, and when that wasn't enough, you worked out the schedule." She was crying now, a raw, open sound that had nothing performed about it, the first genuine thing I had heard from her in months. "I hope the view from Gorge Road suits you," I said. "I understand the rooms are quite small." I turned around. I walked back across the porch, over the boards I had planed and fitted, and set down myself, past the clay pots, past the chair where I take my coffee each morning and watch the fog burn off the straight. I pulled the front door open. I stepped inside. The deadbolt turned with a sound I felt as much as heard, solid and clean and final. Outside, the morning went on. I could still hear it through the walls. Voices, radio static, engines, my daughter's voice rising and then fading into something that was no longer my concern. I went to the kitchen and poured what remained of my first coffee down the drain. I put the kettle on. Through the window above the sink, I could see the edge of the garden along the south wall. The last of the season's lavender, still standing against the October chill. It would come back next year. It always does. The property is mine. The alter ego trust has held since 2018 and will hold until I choose otherwise. The numbered company has been frozen. The construction loan is now unsecured against an asset that never legally changed hands, and the chartered bank has been informed. The pre-sale agreement is void. The demolition crew will not be coming. The oak tree is still standing exactly where my wife planted it. I poured my coffee and carried it to the porch and sat down and looked out at the water, and I let the quiet settle back over everything the way it always does in the early morning, before anyone else is awake, when this piece of ground is exactly what it has always been, mine and no one else's.